Lasky Hirlich, and I'd like to welcome you back to the House again, Minister, and to apologise for being late to the session. I was actually speaking with Alicia O'Sullivan and Jennifer O'Connell about the issue I raised in this House earlier today about Coco's Law. So I want to speak first on the Criminal Procedure Bill that is before us at second stage, but also briefly, if I may, Minister, just to refer again to some comments about Coco's Law and about other relevant legal reforms. So first, just for Labour, I would like to very much welcome this Criminal Procedure Bill and to welcome the provision it makes with indeed its principal purpose to legislate for preliminary trial hearings, and these have been recommended over many years by many different reports and reviews of the criminal justice system. As long ago as 1998, in a study I conducted with colleagues in Trinity, an EU-funded study on the legal process and victims of rape, we recommended at that point in 1998 that pre-trial hearings would be brought in to ensure that issues would be dealt with about the conduct of the trial in a way that would least impact upon the victims and indeed upon jurors, of course. And it's very welcome then to see that is what is being proposed in this legislation, and welcome also to see in particular in section 6 that the interests of the victims as well as of jurors are being recognised here. And I note also, of course, that this will make the trial processes more efficient. I know that my colleague Deputy Brendan Howlin in the other House, also welcoming this bill, referred to an important study last year conducted by UCD School of Law by Mark Cohen, Niamh Howlin, Colette Barry and John Lynch into judges and juries in Ireland, the first empirical study where judges were interviewed. And on the issue of pre-trial hearings, which they also recommended, they noted the frustrations judges expressed about lack of progress on the introduction of pre-trial hearings. One judge saying that they believed it was very disrespectful of a jury to be sworn in and then sent away for long periods of time while issues were resolved in the absence of a jury, as is currently the case. And certainly when I was in practice, I recall being in several trials where the juries would be sworn in and then the voir dires would be held and legal argument would take place in the absence of the jury, often for days at a time, and the juries would be then left in the state of suspension. So clearly that's not ideal for jurors or indeed for victims who are also left often wondering what's going on. So I very much welcome the provision therefore for pre-trial hearings in this legislation. I do also want to again commend you for your work with Brendan Howlin on Coco's Law, but to ask again that we would look in the light of the experience of a young UCC law student, Alicia O'Sullivan, as recounted at the weekend, that we would look again at how Gardaí who take complaints, particularly complaints around sexual abuse, around image-based sexual abuse, how those Gardaí are trained to respond in an empathetic manner and to refer on then to the Divisional Protective Services Unit. And I do want to pay tribute to Chief Superintendent Declan Daly in particular, who's really overseen the important rollout of specialist units within An Garda Síochána across the country to take statements where particularly gender-based violence or sexual crimes are being reported. But I think what's lacking still is sufficient training in Gardaí on the front line in Garda stations who take these complaints in the first place and should be able to refer them onwards swiftly to guards who are specialised in taking statements. And this will facilitate, I think, more efficient prosecution and investigation of such offences. I also, Minister, just wanted to raise with you an issue that was raised on Morning Ireland this morning, a related issue around criminal justice reform by two very brave young women, Una Ring and Eve McDowell, who, like Alicia O'Sullivan, have gone public about their own experience, in their case, experience of very, very serious life-threatening stalking, and their concern that our current legislation doesn't adequately deal with stalking of this sort of violent nature. And they suggested that Section 10 of the Non-Fatal Offences Against the Person Act, which provides the offence of harassment, doesn't really adequately deal with the sort of physical violence that they experienced in stalking, and that it appears more reflective of a more of perhaps persistent communication through non-physical means. Now, while through Coco's law, indeed, we did increase the penalty in Section 10 of Coco's law, we did increase the penalty to 10 years for the Section 10 offence of harassment. I do wonder, Minister, is it time for us to look at creating an offence of aggravated harassment that would more directly encompass this sort of stalking, where somebody is followed at their workplace, where their home or property is broken into, where there's a physical threatening presence that causes them to fear for their lives, as recounted by the two women who spoke. And I think perhaps we need to look also more generally at how our criminal laws reflect the experience of victims. And I do think this Criminal Procedure Bill goes a good way, as a substantial way, towards recognising needs of victims and trying to make trial processes more efficient. But I think we also need to look at our language more generally. Why don't we have an offence known as stalking? Why don't we have an offence of domestic violence? Why do we use language that doesn't necessarily reflect the experience of victims by talking about harassment, which doesn't seem to encompass the more serious type of behaviour? We need to name these experiences. Back in 2018, when we passed the Domestic Violence Act, really pioneered by your predecessor, former Minister Francis Fitzgerald, so ably, we did through our work in the Shannon and the Dáil create a new offence of coercive control, and that, I think, that language more accurately reflects the experience of those who go through what we now know to be coercive control. Similarly, I was really glad that we have a Domestic Violence Act, but we still don't have an offence of domestic violence, just as we don't have an offence called child sexual abuse. And I've spoken before about the myriad of different sexual offences and the very piecemeal nature of reforming legislation we've brought through the House. I should say I acted for the States years ago in cases defending some aspects of those pieces of legislation. But it's a real source of frustration, I think, to anyone involved in supporting victims of sexual crime or gender-based violence that the legislation and the law doesn't seem to just quite match the experience of victims, and it's about looking at our language. It's a little bit like with our outdated criminal law still talking about a defence of insanity, where insanity is now seen as a deeply problematic and outdated expression in mental health and psychiatry practice. So it's about, I think, looking at our language. It's about ensuring that the offences that we create are reflective of the experiences of victims. I know, Minister, you're very much sympathetic to these views, and I wonder then, should we be looking at that offensive harassment and how we can bring it more aligned with experiences of those who suffered the sort of very severe physically threatening stalking behaviours that have been recounted. And like others on this morning's order of business, I just want to finish by saying again that gender-based violence very much in all of our minds today with the news of the tragic killing at the weekend of Jennifer Poole. I just want to extend my own sympathies and the sympathies of my Labour colleagues to her family and friends and all who knew her. So I just finally to welcome this bill, Minister, to welcome the way in which it is framed so as to create, I think, a more responsive criminal justice and trial system, but to say I think there are other reforms that we also need to look at.